So welcome to the last owl call of this season, academic season 22-23 of the Primerus International Practice Institute. Particular welcome to Evan Slavitt, one of our panelists, in-house counsel, with whom I've worked for many years on the subject, and an arbitrator. David, you're here from Georgia, and who else is on the call? Bree, can you find out? Real quick.
Yes, we've got Dan. We've got Eckart. Do you guys want to go ahead and just introduce yourselves and just say where you're from?
Very quick,
Sure.
so that people get to know each other.
Hi, my name is Dan Perrin. I'm an intellectual property attorney with the firm Wiederman Malik in Melbourne, Florida.
Hi, Iker Diegues with Cachot, Cavazos and Newton. We're the member firm for Mexico, and glad to see you this morning.
Thank you. David.
David Gwenethadze, I'm a lawyer at Joint Stock Company Bank of Georgia from Tbilisi, Georgia.
Thank you. Nico.
Hi, I'm an international arbitration attorney. I'm currently a PhD student in Berlin on European private law.
Thank you. Michael.
Hello, everyone. Michael Botnick with Gordon Narada, Montgomery Barnett in New Orleans, Lafayette, and Houston.
Thank you. Carolyn.
Yeah, I'm Carolyn Birubi from HGM Asia Law. I share my time between Singapore and China, and we do M&A and tech.
Thank you. Jacob.
Hello, everyone. I'm Jacob, and I'm working in Hamburg for Professor Brödermann.
Thank you. Lena.
Hello, everyone. I'm a first-year associate also at Professor Brödermann's law firm, Brödermann Jahn in Hamburg.
Great. Thank you. And Nafasat.
Hello, everyone. My name is Nafasat Tashtimirova. I am an international investment lawyer based in Tashkent, Uzbekistan.
Great. Thank you. And today presenting, Marc, would you like to go ahead and introduce yourself?
Sure. I am Marc Dedman. I'm with the Barton LLP based in New York City. We also have an office in Los Angeles. I am in the Nashville, Tennessee office.
Thank you. And also presenting today is Evan.
Hi, my name is Evan Slavitt. I worked with Eckart for many years, particularly on UNIDROIT, and I practice in Charleston, South Carolina. I'm the in-house counsel for Paper Excellence Group.
Thank you. And Eckart.
I'm Eckart Brödermann, in Hamburg, Germany, and chairing this International Practice Committee.
Thanks, Eckart. I'm going to go ahead and share your presentation, okay?
No, we first leave the opening for Marc.
Oh,
Marc,
okay.
Start
go for
session.
Okay, well, thank you. I'm thrilled to death to be the host of this event. I know many of you have heard me supporting Eckart in this effort to educate all of us more on UNIDROIT principles. He convinced me of this a number of years ago. And in fact, I began reading the book. What year was that? 2015, Eckart, flying to Malta on a plane, and completely agree with him that this is the future for less impediment to international trade. So I'm thrilled today to have this conversation with Evan Slavitt, who's already introduced himself, Global Chief Legal Officer with the Paper Excellence Group, and Eckart with Brödermann Jahn out of Hamburg, Germany. And importantly, Eckart is the author of the UNIDROIT Principles of International Commercial Contracts, an article-by-article commentary, which is now reviewed in 19 jurisdictions around the world. It has been written now and translated into Chinese. The second edition was just published and is being currently translated into Spanish and French. And Eckart, I think what would be really helpful at this point is you prepared a slide for us to create a foundation. Is this a good time for you perhaps to show that to us?
Absolutely, and we do it in less than 5 minutes. Bree, can you open the slides?
Mm-hmm.
So it's all about law without borders, or one fits all. If you go to the next couple of slides. Okay, let's start with a journey through time. Do you remember the time without internet, without smartphones, without video calls? That was a time without the UNIDROIT Principles, which were enacted in 1993. So next slide. The premise which we have is diversity and uncertainty. With globalization, you have trade and contract around the globe, and that implies conflicts of law, knowing which law applies when, complex dispute resolution process, often arbitration and comparative law to cope with it. And the UNIDROIT are there to make this more simple. Please show the next slide. They meet diversity in an effective and cost-efficient way, and they thereby significantly limit the risk of uncertainty. And I think by now everybody who's in the call knows that UNIDROIT itself is an intergovernmental organization called the International Institute for the Unification of Private Law, set up by the League of Nations in 1926. So we're not talking about some soft law created by some academics. We are talking about something which was ratified by the 65 member states, including the government of the United States of America. Next slide, please. So you could imagine the UNIDROIT like a chameleon with a little hat. And the hat stands for all the different kinds of contracts which you can imagine. Distribution contracts, sales contracts, framework contracts, joint venture contracts, cooperation agreements, all kinds of contracts. And in all kinds of industries, textile, satellite, shipping, automotive, you name it. We even once built a zoo in China on the basis of the UNIDROIT Principles. Next slide. So they are like the iPhone in 2007, only for international contracts. They're an absolute game changer. If you today work internationally, ignoring them, not without knowing with them, it's like if you use a phone with a cable, not knowing about the iPhone. They are universally applicable and compatible with all jurisdictions. That's the nice thing. You don't have to study extra law on the basis, because they're so universal and they distilled over a period of nearly 50 years from 1970 to 2016, that distilled all the common ground between all these different jurisdictions. You can really work with them regardless of whether you come, like in this call, from Mexico or from Georgia or from Singapore or from Canada or from Germany. Wherever you come from, whatever you have trained, you can work with that. You don't have to study twice. They are neutral, independent. They are common ground for legal practitioners with a common law perspective, a combination of party autonomy, good faith, fair business conduct in all phases of the contract. Essentially what they did in the making of the UNIDROIT Principles over those 40 years is that they went through all steps of the life of the contract. And for each step, they considered what are the rules with the specificity as needed from an English law perspective, while also meeting the good faith principle, which is so important from a civil law or US law perspective. So it's a simple tool, though disruptive, when your home law is not acceptable. It's at least a plan B for some billion people. Next slide, please. So, and with the red headings there, you see that they really run through all the steps of the contract: conclusion of the contract, validity, interpretation. Yeah, interpretation, very simple, 4.1. Interpretation is according to the joint intention of the parties, or otherwise, if you can't find that intention along the objectively find purpose under, I rather give you the good wording of them. It's 4.2, which I just give you as an example. So if you can't determine the intention of the parties, then such statement and other conduct shall be interpreted according to the meaning that a reasonable person of the same kind as the other party would give it in the same circumstances. So for the client, It's cost and time saving. You don't have to research so many laws. It simplifies processes of monitoring. And just give you one example. Just a couple of weeks ago, we had a contract between Germany and India on IP transfer know-how, and they wanted to get some of the money over transferred to Europe, to Germany, from this know-how given over to India. And there was years ago a contract concluded and reviewed by Indian Counsel. And now what happened is that the finance department of a company just took that contract, wiped out the word Indian, wrote in Chinese because it was now needed between Austria and China. And that, of course, doesn't match. You can't just change Indian law to Chinese law. It's kind of difficult. They have different background. But the moment you do it with UNIDROIT and you develop the contract between India and Germany on an UNIDROIT principle basis, you can use that frame and use it as a template also for the Austrian-Chinese contract. And that is the kind of thing which UNIDROIT just simplifies and helps you save money. So it's no gambling with foreign law. It's management with the diligence of a prudent business person. And for lawyers, it means market expansion. In my example, which I just give, in a diligent lawyer just working with national laws, you would have needed German counsel, Austrian counsel, Indian counsel, and Chinese counsel. And the way we did it, you could very much streamline the process and at the end just hand it over to the Chinese and ask, is there anything from the mandatory law perspective which we should consider? So you really streamline cost. So it's cost saving and risk reducing, no gambling with foreign law, quality of advocacy works increases, your clients are more satisfied. That's in a nutshell. And maybe next slide, if there is still one, there's one more. So in a nutshell, take the UNIDROIT principle and combine them with an arbitration clause, and then you end at what I would like to call simplified global contracting. And now comes the very last slide. You can feel at home when using UNIDROIT. Yeah, it's developed by many bright minds around the globe, proven in many arbitration awards, available in 12 languages. Ukrainian, the 13th language, is just coming. My factual stepdaughter just did it. It's universally applicable, developed over 50 years, based on 2,000 years of legal history. And it's recommended by the United Nations Commission on International Trade Law. They made a resolution, recommended it. The Union Internationale des Avocats, unifying through its bar state members about 2 million lawyers, they also recommended to their members to use. And Primerus, of course, made a formal resolution to recommend it to its clients, to the ACC friends, and to its members. So it meets German requirements, but just the same way New York requirements or any other requirement in any other jurisdiction as well. So much maybe as a nutshell, as a starting point. You can
Thanks, Eckart. Go ahead. Thanks, Eckart. You know, I said on the front end how excited I am to be the moderator for this program, and part of that is I want to reinforce. You know, Eckart not only is an outside counsel that utilizes the UNIDROIT principles, he's the author of this book. And before becoming the author of the book, he was actually involved in the process of drafting the articles themselves from 2004 to 2010. So we had this incredible knowledge base right there. But what makes me even more excited about this, not only is Eckart here to discuss this with us as an outside counsel that utilizes it for his clients, we've got Evan Slavitt, who is in-house counsel, who can discuss what he believes from the in-house counsel perspective, the value to him of the UNIDROIT principles, and hearing from his outside counsel the utilization of that. And so with that, Evan, I want to turn to you. And, you know, with respect to what Eckart just said, what do you have to say about that? And secondly, to what extent do you even use the UNIDROIT principles? Can you share that with us?
Sure. I was converted to the UNIDROIT principles some years ago by Eckart because it solved or helps to solve a problem that I face all the time in my practice as an in-house counsel. which is Paper Excellence and my previous company, Kyocera AVX Corporation, are both international companies that do a lot of international contracting. And one of the annoying parts of international contracting is dealing with all the stuff in the back of the contract that lawyers care about and the business people just want to get done. And one of the problems that I faced was that I have a United States background and the companies are United States companies. But we deal with people who are not only in different countries, but have a fundamentally different approach to how they think about contract interpretation and how they think about the legal framework. And so it was always a tug of war. You know, they wanted, let's say, Germany. I wanted the United States. Sometimes we would compromise on something like United Kingdom, which was semi-unsatisfactory for everybody. Or we'd pick a country that neither of us was familiar with, like France or Switzerland, just on the theory that at least it wasn't our home country. But again, those were unsatisfactory because all we're doing is we're sort of randomly picking a different framework. And I found that using the UNIDROIT principles as a proposal, because they sort of are a confluence of the Anglo-American approach and the continental approach, that simplified things because we were picking a choice of law that was neither mine nor theirs, but was a coherent approach that we could even tweak if we needed to, but allowed us to settle on a set of contractual principles that was a compromise that was designed specifically for this purpose. And so I found that while it's still something of a sales process, because not everybody in the world is familiar with the principles, if I use that as a starting point, it's a much more productive way of going than if I simply, I write in, you know, US law, they write in German law, and then we just wrangle about it. So from my perspective, it gives us a substantial step up. And I'm sure Eckart will expand on this, but I also use it in conjunction with an arbitration clause. And that allows us to set up an arbitration clause where the choice of law that the arbitrators are going to use is again a compromise. And we start out from that point of view, and that is a much more congenial approach. So that's why I found it very helpful.
Eckart, let me ask you a question. It may be self-evident by what Evan just discussed with us, but for those of us watching or listening to you and Evan today, why do the UNIDROIT principles matter to us? Why should we turn to something that we're less familiar with versus what we may have utilized for some of us decades in the past? You know, why does this discussion matter to us?
Compared to gambling with foreign law, what Evan just described, when they compromised in the early beginnings on French or whatever other neutral law, or once I had Belgian law because it was in the middle between America and Germany. Before you do that kind of thing, where you really gamble, where you really don't know, you don't invest all the time of studying what that all is all about. Compared to that, you manage your risk, you increase quality, clients become happy, you earn money, and you save time.
Evan, based, you know, what Eckart just said, let me ask you this question. You've got primarily outside counsel who's watching this. What is your opinion or your impression of outside counsel who don't know the UNIDROIT principles, may not have even heard of the UNIDROIT principles when you raise that with them as a potential option for an international contract?
Increasingly, I am frustrated by outside counsel who are unaware of this. You know, it is a tool. It is a tool that they should be aware of. It's a tool that if I didn't know about them, which is not impossible for in-house counsel, we have many demands on our time and we can't keep up with everything, that I would assume that they would at least offer me if I didn't know about it. And if I put it on the table and I say, when I'm using outside counsel for these contractual negotiations, I say we want to use the UNIDROIT principles, and they don't know about them, that suggests to me that they're not actually trying to keep up with the current trends in international contract. So even as a defensive matter, even if you're not going to advocate them, because for some reason or other you don't like them. I think it's important for outside counsel to at least have a working knowledge of the UNIDROIT principles, because otherwise you're not fully counseling the clients and giving them all the tools that they could possibly need.
Thanks, Evan. Eckart, I guess building on that theme, 2 years ago, you'll recall you and I, along with in-house counsel for another U.S. corporation, very large Fortune 500 company, we gave a CLE in Tennessee having to do with the UNIDROIT principles, which was put in the state's Tennessee Bar Association library. But you used some words in that I've remembered since then, a bridge over troubled waters. Can you explain to us what that means in context of UNIDROIT principles and what that does as a bridge over troubled waters?
Yes, the troubled waters stand for all the different laws. And by really distilling compromises for 211 issues, how to do it, they really developed this kind of bridge. And take the example, if there's a contract and there's a breach of contract, what would an American think of? You think in terms of damages. What, in contrast, would come to the mind of a civil law trained lawyer? They think in terms of specific performance. So different starting points. But if you melt it down, you end up at a compromise in the principles, which is absolutely acceptable. For example, they started by saying, if you want money, payment of money, does it matter whether you call it damage or specific performance? In the end, it's just money you want to claim. And if you have a loan and the payment back of a loan, you can claim that money. So people agreed that for half of the claims, or everything for money, it didn't matter whether you call it one way or the other. So there is a principle that if you have a claim for money, you can claim it. Call it specific performance or not, doesn't matter. Once you made that step, you can also go to the other things. But then you need a large group of exceptions so that Americans feel happy. And all in the end, what's in the principles is the same kind of mix which you have through cases in your also in American law. So if it's, for example, impossible, or if it's economically unsound to go for specific performance, then it's excluded also under the principles. So that's an example of one of these bridges.
Well, thanks for that. And Evan, I want to follow up again, I guess, on this same concept, and that's the bridge over troubled waters. So Eckart has given us a really good macro overview of the troubled waters that can be faced. You as in-house counsel, you don't look at the macro picture necessarily with respect to a specific contract that you may be engaging in or one that may have gone sideways. Give us some examples on a micro perspective of incidents or problems that you have experienced that the UNIDROIT principles help resolve.
Well, I mean, I guess I come back to the fact that, historically, 10 years ago, there was no easy compromise position. There was no suggestion I could make that would immediately appeal to the other side as being a soft approach. In other words, I could come in with, instead of saying United States law, I could come in, let's suppose I was dealing again with a German company. And I only pick on Germany because that's where Eckart's from, and he knows my feelings about German law. I would come in and I could say, all right, I'll start out with a compromise position of UK law. Well, the problem is that for a German lawyer, the Anglo-American approach, that wasn't really a great compromise for them. In other words, it's clearly not my law, but it's not really their approach. They don't really think about approaching contracts the way that a UK court would approach contracts. So we would wind up having to either tweak a bunch of things, or I would wind up having to concede to a continental approach. And we just pick France over Germany for no good reason, and it was facially a compromise. But I was essentially conceding the point. By starting with something that is intended to be sort of mid-Atlantic, if you will, I already start with a softer approach that suggests that I'm trying to get to yes. I'm trying to get to a deal. And that makes everything easier. In other words, the point is not for both of us to start at the antipodes and then slowly move in, because that takes forever. The point is to come in with an approach that suggests that we're trying to accommodate the deal that our commercial people have already said they want to accomplish. So just in terms of things like understanding what is the good faith, the compromise on the notion of the covenant of good faith and fair dealing, which is a US concept. That sort of thing allows me to offer an olive branch in a way that I couldn't before. And it allows them to go back to their clients, their internal clients, or if I'm dealing with outside counsel, their clients, and say, listen, I know the choice of law seems a little odd because you haven't heard of this, but it's not a concession to them because they're trying to reach a deal. And again, for me, the academic piece is not prominent. For me, the deal is to paper the agreements that my clients, my internal clients, already want to reach. And UNIDROIT gives me a tool to do that. Also, when in the occasions when we do have to go to arbitration, and we're doing international arbitration, and we have one arbitrator who has an Anglo-American background, and let's say two arbitrators who come from a civil law background. One of the things that it allows me to do is it's easier to explain to the arbitrators what we're trying to accomplish. And they have this fairly detailed set of principles that allow them to do what they do rather than having to tangle internally over the two approaches. So I guess I think of it as a practical thing rather than it is, it has its own intellectual justification, but for me, it's a practical.
Thanks, Evan. That's actually very helpful. I want to stick with you. I want to ask you a follow-up question. I'm sitting here, I'm looking at the screen, and I see the pictures of everyone who's sitting here with us. And so I've identified three. I'm going to call out by name. Coincidentally, they're all from civil law jurisdictions. Having said that, they all three have very different approaches to the law. I see Patricia Barcelos on here from Brazil. I see Pascal Ladai here from France, and Michael Botnick from New Orleans, Louisiana, which is the only civil law jurisdiction in the United States, by the way. Having said all that, they all three approach this differently. So let me ask you, one of them, Pascal, Michael, Patricia, comes to you and your in-house counsel there in the law department and suggests to you the UNIDROIT principles. What's been your experience when you speak to the CEO or others internally there at the corporation that rather than use the common law or the UCC or CISG or some other regime, you recommend that they use UNIDROIT? What has been the reaction when you suggest this?
I really hate to disappoint everybody who thinks that all of our CEOs are these steely-eyed people who want to dig into things like my recommendation on choice of law. I would say their recommendation is a slightly blank look if I feel compelled to brief them in on it at all. And they immediately say, whatever you think is fine. Try desperately to move the conversation to something that they care about. The reality is there is not a lot of internal resistance. On the rare occasions when one of my commercial people say, what is that? I have my short answer, which is basically the one I've given, which is it's a compromise position that allows us to expedite getting the contract signed, and they are more than happy to accept that explanation. So I don't believe that there is any internal resistance. I suppose there may be a few people like me who work for a CEO who used to be an in-house counsel. That's not entirely uncommon. But I have yet to meet one where the CEO is spending, or the head of sales is spending an enormous amount of time on any page of the contract other than the first one.
Thanks, Evan. I'm going to stay on this theme, Eckart, and turn to you. I see also some U.S. attorneys here, Dan Perrin out of Florida, Melissa Lagu out of Michigan. So let me ask you a question. We were trained on UCC and many times default to either New York law or Delaware law. Are there examples that you can give to us here in the United States where the UNIDROIT principles actually work better than, say, the UCC or New York law that we were trained upon, that would cause us, or at least pique our interest, to learn more about the UNIDROIT principles?
Yes, of course, because national laws are made for national jurisdictions with national scenarios in mind. And the UNIDROIT principles have been created for international commercial contracts. So what is the rule if you want to set off a claim in dollars versus a claim in euros or renminbi? That is something which, for example, under German law doesn't work because it's not equal kind of claims. But the UNIDROIT principles deal with the specificity of how to cope with set-off under foreign exchange, depending on the convertibility of the currency. So that's an example. Time zone management is another example. You set a time, but usually you don't put in the contract, do you think that the other person is sitting with 5 hours time difference, etc. These kind of things are often not thought about. So there are a number of these very special, typically things which are very typical for international trade. Let me make, though, a footnote on the UCC. When the UCC was created in the early 1970s, it was a huge, huge invention, breaking news to English or Australians at the time, to say that the big United States of America made this big step and said, we do everything, also integrating the principle of good faith and fair dealing. So the UCC was a huge accomplishment, but at that time brought in something new. And the UNIDROIT principle is just doing this thing on the next slide, bringing it to an international level. So any national law may be for national purposes the best you have. But if somebody comes to me and says, for example, let's do it under law of Michigan, then basically this party is putting over to me the cost of finding out what was the law of Michigan. Frankly, from Germany, I have no chance to find out what the law of Michigan unless I invest a lot of money in order to find it out. So instead of bossing me around, it's much fairer if we agree on something neutral like the UNIDROIT principles.
Let me add to that, Mark, let me add to that, which is there is a sort of tapestry of background that also affects people's instinct. I grew up in the United States legal profession. So that means that I'm used to courts making a lot of court-made law. I'm used to the idea that if you want to look up the law of any particular jurisdiction, I don't just consult the statutes and regulations, I read all the cases. When I deal with lawyers in other countries outside that tradition, that's a different way of thinking than the way of thinking that they have. So if I'm in South Carolina and I choose Delaware law, I'm still taking the same approach. We're just sort of compromising on some very minor details. Whereas the difference between US law, whether it's South Carolina or Delaware, and let's say the law of Mexico or the law of Brazil, they're profoundly different ways of thinking about things. And even after practicing for over 16 years as a general counsel of an international company, I have to profess my instincts when it comes to the law of Germany or the law of Brazil are not reliable. And so if I have to rely on the law of Brazil in a big contract, I have to retain Brazilian counsel to at least make sure that I haven't done anything disastrous. Because you can't just write a contract that's designed for US law and then plug in Brazilian law and hope that everything works out. It just doesn't work that way. And so by using the UNIDROIT principles, I kind of avoid that diversion because a generic template contract that I write, I can be pretty confident I know how it'll work under the UNIDROIT principles. So that makes a big difference to me, both in terms of cost and timing.
Thanks, Evan. Actually, that was great. It teed me up for the next question. Eckart, and I'm going to ask you that. So you talked a few moments, you just heard what Evan had to say. A few moments ago, you talked about, I guess, a differentiation or distinction between UNIDROIT and the UCC. What about a default to the Convention on International Sale of Goods, CISG? Why would the UNIDROIT, or how does UNIDROIT address some of the issues that may apply with respect to CISG application? What are the differences?
The CISG is the result of study first by Ernst Brabel in Austrian in the 1930s, finished in the 1950s, and then compromised in the 1970s by the United Nations. End of 79, end of debate, April 80, they agree. So basically that's the status of the compromise, which is now 40 years old, of the civil and common law jurisdictions compromising on the specific issues of the sale of goods. So what UNIDROIT did, they went on. After 1980, the next 40 years, they worked on all the other issues. What about the general contract issues? Like conclusion of contract, like validity, like threat, like error, like plurality of obligors or obligees, prescription limitation of liability. So there's so many other issues which are of more general nature. So the CISG is more specific and the UNIDROIT is more general. The moment you have a complex contract with not only sales, but maybe also marketing or agency around or distribution aspects or territory aspects, then you're beyond what is in the CISG. So very often you may even combine it. You can take the CISG, supplement it for those issues which are not covered by the CISG, by the UNIDROIT principles. On occasion, I've done that. But you can also simplify it and just go for the UNIDROIT principles.
Yeah, allow me to add one thing on that. And I'm allowed to say this because since I'm in-house counsel and I'm just sitting here in South Carolina, I don't have to be quite as diplomatic as Eckart. The CISG was a total fail. I would say 99.5% of all the contracts I ever receive, certainly all the ones I send out, explicitly disclaim the application of the CISG. It just didn't work. Nobody likes it. Nobody really understands it. It's just not going anywhere. And it could have been a great idea, but it didn't work. UNIDROIT is one that has not had a weight. I think there's some weight of opinion in favor of it, but it is not generally conceived to be something that nobody likes. So it's something that I can sell. I can't even imagine trying to convince somebody at another company that sends me a contract with an explicit exclusion of the CISG to have a debate with him, her, or they about whether or not maybe we should go back to the CISG principles, because in the international contracting community, they're dead. UNIDROIT, on the other hand, is a much more vibrant embodiment of that approach or that intention that is not only viable, but I think pretty strong.
Thanks, Evan. That leads me to a question I want to ask both of you based on what you've each now said, the last couple answers. And that is, we've talked about the benefit of utilizing the UNIDROIT principles, but now you've both talked about the negative side or the risks generally of the UCC, of CISG, of New York law. What are some specific examples of risks that you have seen trigger as a result of using what many of us would ordinarily use as simple default terms in a contract that the UNIDROIT principle addresses and overcomes? Just some specific.
I'll give one example. which is German. I don't want to speak. I'm going to speak on my perception of German law. Eckart can correct. But there is a hostility in German civil law to template contracts. I don't know why, but they don't seem to understand that if you're an international company, you don't start with a blank piece of paper and everybody starts writing from scratch. So if we revert to German law, there is the possibility that a German court or an arbitration embodying German law would simply reject something because it's part of my template, not because it wasn't actively negotiated. If I say instead UNIDROIT principles, there is no such hostility to the template. And so I don't have to worry that the very nature of the fact that I sent out a 16-page standard contract will be held against me, not just as drafting principle, but as the principle that we just don't like companies that have templates, right? Setting aside the fact that my company has to do hundreds, if not thousands of contracts a year, and I can't start from scratch with every single one. So that's an example of something that many of my colleagues are not necessarily aware of because they look at the one provision of German law that's relevant, not aware of all the other landmines that exist in other provisions of German civil law that could affect the fundamental viability of their contract. And so that's the kind of thing, by shifting over to UNIDROIT, I avoid these landmines because the arbitration panel can't suddenly reach into their bag of tricks on German civil law and say, we've decided to invalidate the contract. That's just one example, but it's the kind of thing that I worry about all the time because I'm not admitted to practice in most of the countries that we do contracts with. And so I have to be wary of the fact that my superficial knowledge of what provision A in German civil law says about something is not superseded or chipped back by a whole bunch of other stuff that I'm not aware of. Eckart?
I could not agree more. And the example is perfect. And that's, for example, a reason why we as a German law firm always use the UNIDROIT principle when we agree on limitation of liability with our foreign clients. And just very abstract, another example, you know, all Columbia University, famous university in America. There is Professor Alexander Garrow. He brought out, together with Rodriguez last year, a book called, more or less, UNIDROIT Principles to Supplement Domestic Law. And he made a research about over 20 jurisdictions showing of how the UNIDROIT principles can supplement domestic law, especially old domestic law. And we have hundreds of decisions of national courts applying the UNIDROIT principles as a natural interpretation or prolongation or supplementation of the domestic law. You find jurisprudence of the Supreme Court of Paraguay, Supreme Court of Colombia, and of many, many other nations. In Spain, we have over 100 national court decisions using the UNIDROIT principles to supplement Spanish law.
Thanks, both of you. Eckart and Evan, I want to stay with this, or I guess ask to both of you, and that is, when I was in law school, I never heard of UNIDROIT. In fact, I didn't hear of UNIDROIT until, 10 years ago, I guess, from Eckart. At some point, if I'm going to guess that most people on this Zoom meeting today don't know much about it. And so how was it that you shifted from CISG or from the UCC or from New York law or whatever the German law, whatever it may be? How was it that you started making that shift? And how can we start making that shift ourselves so that we can discuss this with our clients?
I think it's an educational process, and I'll be candid. I've been an advocate of UNIDROIT. I still wind up having to educate opposing counsel or in-house counsel that I'm dealing with on contracts about what it is. It is not necessarily always easy, but I guess I would make 2 points. One is I have found opposing counsel to be open to the idea because many of them recognize the same problem that I recognize, which is if they specify German law, it feels like they're hometowning me, and I get immediately reactive to that, so they're looking for the same solution I am. And the second thing is, sometimes we don't wind up settling on UNIDROIT principles, but the idea that I've offered them is a thing that in and of itself helps to make the negotiations go a little bit more collegially. So there is always going to be an educational effort. I think that, I'm a member of the Association of Corporate Counsel, and the International Committee is, this is another thing that we're trying to educate in-house counsel about. So it's going to be a longer term activity, but at least tabling it as a topic of discussion has a value in and of itself. And there are times when the other person says, I don't know this. And I say, all right, we'll pick it up next meeting, but take a little look at it and see what you think. And I get somebody interested in it, and then they start to use it. So, it is incremental, but I particularly think that outside counsel needs to have it in their armamentarium so that they can both advise their own clients and be aware of the possibility of putting it in play in negotiations.
Okay. I made it when I was in an arbitration in Switzerland, and we were trying to argue the applicability of English law. The other side was trying to argue the applicability of Swiss law. And upon invitation of the arbitrator, we then settled jointly with pathological, so not well-drafted choice of law clauses. We settled on the UNIDROIT principles. Because we found out, and we had only 3 days to decide this in a $100 million case, we found out that it really didn't matter whether in the end we have English law taking a remote test, we have the French approach of foreseeability, or whether we have the German approach of whether there's an adequate causality between the event and the damage. So whatever it is, in the end, it's in the end of the arbitrators based on the facts which you have to submit. And the UNIDROIT principles are so well drafted in the compromises that even if I draft today a contract under German law, and I know it's going to be translated for US colleagues, for example, then I very often integrate rules from the UNIDROIT principles in my contract under German law or under any other law. And give me as an example, 747. It gives you one example for this kind of clause, where the harm is due in part to an act or omission of the aggrieved party or to another event for which that party bears the risk. The amount of damages shall be reduced to the extent that these factors have contributed to the harm, having regard to the conduct of each of the parties. That's in essence similar as we have it in German law, but to find it in German law, you have an old provision of 1900 to be revisited together with commentaries, etc. So much on that.
Thanks, Eckart. I just reached back. I actually have your book, as you know, autographed, as a matter of fact. Thanks for that Eckart. But I look at this, this is the UNIDROIT principles.
Well, in fairness, Mark, that's not just the UNIDROIT principles. That's the UNIDROIT principles with a lot of explanatory text. Actually, so I don't want people to think that just reading the principles requires reading that entire.
Thank you for that clarification. I don't want to scare people with that. What I do want to say, though, is that for those of us who do not come from this training background, this experience, are there a few default principles that we can look to first and start there, become comfortable with that, and then build upon it, build this construct that over a relatively short period of time, we can also become very conversant in the benefits of the UNIDROIT principles?
Start with 1.1, 1.2, and 1.5, all saying party autonomy. You can write in your contract everything as long as it's not utterly, extremely unfair. So for that, you can start with your template, whatever is the law on which you initially, under which you initially structured your template. Second, look at Article 1.7, that you should deal with the underlying principle of good faith and fair dealing. And if you have somebody from an English country where certainty trumps equity, then you can tell them, no worry, there are over 80 examples of detailed rules. For example, 1.8. You should not do one day X and the next day the opposites. Then it's against the expectations which you have been raising. So, it's very simple. Or 1.4, if there is mandatory law which intervenes, then we have to respect it. There's no briberies, no bribes, no money laundering, etc. That comes first.
All right, Evan, same for you. When we go to our clients and suggest the UNIDROIT principles, they're in-house counsel, and they may have heard about it, but they don't know much about it. What is it that we should come to first with someone who has not used this in-house that they may be of interest to hear about?
I just have to agree with Eckart. You know, start with those fundamental principles, which give the arbitrators a chance to decide that the parties really agreed on this, and therefore they should put it in place. And then, as you get more comfortable, expand out.
You know, Eckart, we're starting to run short of time, but I do want to ask this question. In speaking with you through the years about this, you've spent almost a year's worth of time over the last, I guess, 5 or 6, 7 years studying UNIDROIT, writing the book, the original, now doing the second edition of the book. What are some of the most important things that you have learned in this journey that you've taken over the last 5, 6, 7 years with respect to UNIDROIT?
Especially also looking at the roots and the history of all the different compromises, that really each of those compromises embraces both the need for certainty of English lawyers and the need for good faith and fair dealing from civil law lawyers or US lawyers.
Thanks for that. And actually, we still have a couple minutes left. And I guess, are there any primary or more significant takeaways that either of you have to offer for those of us watching this today or not as conversant in UNIDROIT as the two of you are?
I guess from my point of view, it's a process. You know, I'm not going to say that when I first started dealing with it 10 years ago, I immediately read the entire book and, you know, went in that direction. But like any kind of organized system, it's relatively coherent, it's thoughtful, it's moderately intuitive. And so the more I got familiar with it, the more comfortable I was that even the provisions that I hadn't spent a lot of time with were likely to be appropriate for my approach to contracting. So again, you know, I don't want people to be under the impression that they have to have everything before they can even start with it. But it is useful to spend an hour or so getting familiar with the overall structure of UNIDROIT, particularly for outside counsel, so they have it ready to go. And if they're asked a question about it, they understand the framework of the question. So I guess that's sort of my approach, which is you can just dip your toes in the water. But I think you'll find that the water is, I found at least, that once I did that, the water was quite welcoming, and I continued to go in that direction.
Eckart, anything to add to that?
I concur.
Well, that makes it very easy, and we are getting very close, but we do have a couple minutes. I'd like to turn this back over to Eckart, who is the chair of the International Practice Committee for Primerus, to discuss, I guess, what we've talked about today and your vision for the upcoming year that we'll have beginning of September.
Before that, David, you have one question, very short, please.
Can I ask about the principles of European contract law, the PCL? As I know, it's pretty much a similar project within the European Union. Can you remind of any cases when you applied this in international transaction?
Yes, to cut it very short, they exist. They are very much akin to the UNIDROIT principles in many regards. There are some nuances, but they are mainly academic, while the UNIDROIT principles exist in practice. So from a global perspective, there are no alternative. And when I have the option to choose something, I always choose the UNIDROIT principles. And with that, I want to hand over to the more larger frame, this is the last call of our 22-23 academic year of the International Practice Group. We are going to go into our summer break. We will reopen on September 19 with an owl call. I think that's already the one integrating young lawyers. I would like the okay from everybody, if that would be okay, that we could even load this session, which was videotaped, up on YouTube for others to see. Would there be a consent on that point?
Yes.
Thank you very much. I see a lot of nodding and acceptance. Thank you. So with that, Bree, I hand over to you, and please show that to everybody so that other people can see and make up their mind. But I think would be a great thing to really share this session, which we had with lawyers around the globe.
Yes, thank you. And thank you everybody for being here today. Evan, Mark, and Eckart, great presentation. And thank you guys. And I look forward to seeing everyone on the next season of IPC.
Thank you.
All right.
Okay.
Bye-bye, everybody.
Bye. Nice to see you all. Thank you for the great presentation.
Bye-bye.